Hello and welcome everyone. So, আজি আমি এটা নতুন লেসন start কৰিব লৈছো on Indian polity that will be fundamental rights. So, it is one of the most important topics of Indian polity for both mains and prelims perspective. So, এইটো এটা lengthy chapter হয়. So, আমাক কেইবাটাও ভিডিও লাগিব এই চ্যাপ্টাৰটো শেষ কৰোঁতে so that we can have a detailed analysis and this will be part 1. So before we proceed, I request you to please subscribe to our channel so that you can get timely updates of our videos. আৰু মই ৰিকুৱেষ্ট কৰিম যাতে আপোনালোকে ভিডিঅ'টো লাইক কৰক আৰু শ্বেয়াৰ কৰক so that others get benefited. So let's get started. So fundamental rights are enshrined in part 3 of the constitution and it covers article 12 to 35. আমি আগতে যেতিয়া আমি source of the constitution পঢ়ি আহিছিলোঁ তাত আমি পাই আহিছোঁ যে fundamental rights have been taken from the Constitution of USA, jot fundamental rights of Bill of Rights bili koa hoy. Then part 3 of the Constitution is described as the Magna Carta of India. Kyo koa hoy? Because Magna Carta was the first written document on fundamental rights and it was issued by King John of England. Then fundamental rights are guaranteed by the Constitution to all the persons without any discrimination. Then fundamental rights are meant for promoting the ideal of political democracy. So fundamental rights এটা ensure করে যে state বা central government বা যিকোনো authority citizens এর উপর যাতে unnecessary কিছুমান restriction আনি দিব নোৱাৰে. So it promote political democracy by providing freedom and liberties to the citizens. Then fundamental rights are named so because they are guaranteed and protected by the constitution. So আমি জানো যে our country is run according to the provisions of constitution. Our constitution is a fundamental law of the country. Hence these rights are known as fundamental rights. Originally at the commencement of the constitution we have 7 fundamental rights. Amar 7টা fundamental rights আছিল. হেকেটা হল right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to property and right to constitutional remedies. গতিকে ইয়াৰ আগতেও আমি বহুতবাৰ ডিসকাস কৰি আহিছো যে right to property under article 31 has been removed from the list of fundamental rights by the 44th Constitutional Amendment Act of 1978 and now it is a legal right under article 300A. So এতিয়া আমি ডিসকাস কৰিম some of the features of fundamental rights. So some of the fundamental rights are available only to the citizens. For example, article 15 or article 16. Article 15 কোৱা হৈছে যে there should be no discrimination on the basis of religion, race, caste, sex or place of birth, etc. So this is also available to the citizens of India. Tenukwa bahut fundamental rights ase, those are only available to the citizens, while others are available to all the persons. All the persons mane hol Indian citizens hobo pare, foreigners hobo pare or any other legal persons, for example corporate association, company, etc. For example, under article 21 amar dia ase right to life and personal liberty. So this is available to all the persons. Then they are not absolute but qualified. Kyo? Karon the state can impose certain restriction on fundamental rights in some special circumstances. The best example hobo amar etiar situation to. For example, etia ami we are not allowed to move freely around the country or in our own locality due to coronavirus. So আমি তো ক'ব নোৱাৰো যে this is violation of fundamental rights because extraordinary situation demand extraordinary measures. Then most of them are available against the arbitrary action of the state. So arbitrary action মানে হল কিছুমান unnecessary restriction বা কিছুমান random decision by the government. So আমি যদি আগৰ example টো লওঁ যে suppose after a full recovery of coronavirus যদি আমাৰ government the same restriction আমাৰ ওপৰত থৈ দিয়ে বা জাপি দিয়ে, so that will be violation of fundamental rights. Then some of them are negative in character while some others are positive in nature. Negative in the sense যে fundamental rights put some restriction on the state যাতে তেওঁলোকে নিজৰ ইচ্ছামতে কাম কৰিব নোৱাৰে, যিকোনো ডিসিশন নিজৰ ইচ্ছামতে ল'ব নোৱাৰে. Positive in the sense যে they give some certain privileges or rights. For example, right to religion, right to freedom, right to life and personal liberty. So enukwa. Then they are justiciable. So when fundamental rights are violated, we directly go to the court of law and in turn they are defined and guaranteed by the Supreme Court. Then they are not sacrosanct or permanent. So parliament can repeal or curtail certain fundamental rights. For example, ami right to property kotha kobo paru. It was removed from the list of fundamental rights by Constitutional Amendment Act. কিন্তু fundamental rights এটা নোহোৱা কৰাৰ কাৰণে the parliament has to amend the constitution. Ordinary law দ্বাৰা fundamental rights নোহোৱা কৰিব নোৱাৰে আৰু যদি fundamental rights to remove কৰোতে it strikes the basic structure of the constitution, then it can be declared null and void by the Supreme Court. Hey lawখন illegal বুলি Supreme Court declare কৰিব পাৰে. Then they can be suspended during the operation of national emergency except the rights guaranteed by the Articles 20 and 21. Then we have their scope of operation is limited by Article 31A, 31B and 31C. গতিকে এই তিনটা আৰ্টিকেল কি হয় লাষ্টৰ পিনে আমি ডিটেইলছত ডিসকাস কৰিম. Then their application to the members of armed force, paramilitary force, police forces, intelligence agencies and analogous services can be restricted or abrogated by the parliament under Article 33. So defense personnel or fundamental rights may not be available and they can be restricted by the parliament. Because they are subject to national security. Then their application can be restricted while martial law is in force in any area. গতিকে martial law মানে হল military rule. যত military rule চলি থাকে fundamental rights may not be available. Then most of them are directly enforceable or self-executory, while a few of them can be enforced on the basis of a law passed by the parliament. Then definition of state. গতিকে আমি state মানে জানো যে ৰাজ্য এখনক state বুলি কোৱা হয় বা কেতিয়াবা দেশ এখনক state বুলি কোৱা হয় কিন্তু under Article 12 of the Constitution stateক এটা wide range of definition দিয়া গৈছে যত almost all the organs of the country have been included. ইয়াত include কৰা হৈছে government and parliament of India, that is executive and legislative organs of the union government, government and legislature of the states, that is executive and legislative organs of the state government, all the local authorities, that is municipalities, panchayats, district boards, improvement trusts, etc. Then all other authorities, that is statutory or non-statutory authorities like LIC, ONGC, SAIL, etc. and any other private companies. So আমি গম পালো যে a wide range of components have been included in the definition of state so that no one can violate the fundamental rights of the citizens of India. Now, laws inconsistent with fundamental rights. Article 13 declares that all the laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. So, যিবিলাক law fundamental rights violate কৰে they can be declared unconstitutional by the Supreme Court of India by their power of judicial review. এতিয়া এই under Article 13 under কি law আহে আমি এখানে চাই লও. So permanent laws enacted by the parliament or the state legislature. Temporary laws like ordinances issued by the president or the state governors. Then statutory instruments in the nature of delegated legislation or executive legislation like order, bylaw, rule, regulation or notification. Then at last it covers non-legislative sources of law, that is custom or usage having the force of law. So it also covers a wide range of definitions. So এতিয়া আমি discuss কৰিম right to equality. So it covers from Article 14 to 18. And the first one is equality before law and equal protection of laws. So Article 14 says that the state shall not deny to any person equality before law or equal protection of laws within the territory of India. This provision confers rights on all the persons, whether citizens or foreigners. So a right to citizens or foreigner দুইটাৰ কাৰণে available. The concept of equality before law is of British origin, while the concept of equal protection of laws has been taken from the American Constitution. So এতিয়া আমি চাম equality before law মানে কি. So it means absence of any special privileges in favor of any person. The equal subjugation of all persons to the ordinary law of the land administered by the ordinary law courts. Then no person is above the law. So in simple terms যদি আমি বুজিব খুজো এইটোৱে বুজো যে ডেকৰেটেড গভৰ্ণমেণ্ট অফিচাৰ এটাই হওক বা এটা ফ'ৰ্থ গ্ৰেড এমপ্লয়ী হওক ধনী হওক বা দুখীয়াই হওক চবৰে কাৰণে ল ইকুৱেল হয়. ইকুৱেল প্ৰটেকশ্যন অফ লজ. The equality of treatment under equal circumstances both in the privileges conferred and liabilities imposed by the laws. The similar application of the same laws to all the persons who are similarly situated. The likes should be treated alike without any discrimination. So এই কনসেপ্টটো বুজাৰ কাৰণে আমি এটা এক্সাম্পল ল'ব পাৰো. The example of the landmark judgment of Nirbhaya case. So Nirbhaya case to total convict আছিল 6 জন. one of them is died during the trial in the jail. জেলতে এজনৰ মৃত্যু হৈছিল। বাকী থকা 5জনৰ 4জনক ফাঁচি দিয়া হৈছিল এইটো বছৰৰ 20 তাৰিখে, মাৰ্চৰ 20 তাৰিখে। And the other one is tried under Juvenile Justice Act and he was sentenced to jail for 3 years, after which he was released. So ইয়াত আমাৰ দুটা কেটেগৰী আছে, এটা হ'ল এডাল্ট কেটেগৰী, এটা হ'ল জুভেনাইল কেটেগৰী। So like should be treated alike মানে হ'ল যে 4জন এডাল্টক সেম ট্ৰিটমেন্ট দিয়া হৈছে for the same crime, কিন্তু unlike should not be treated alike। unlike হ'ল যে জুভেনাইল কেছৰ যিজন ল'ৰা 18 ইয়াৰ্ছৰ তলত আছিল, he cannot be equated with the adults, so he was tried under Juvenile Justice Act and 3 বছৰ জেলত ৰাখি তাক এৰি দিয়া হৈছিল because he was under 18 years of age। so এইটোক লৈ বহুত কন্ট্ৰভাৰ্সি হৈছিল কাৰণ সেম ক্ৰাইমৰ কাৰণে তাক অকল 3 বছৰ জেলত ৰখা হৈছিল and he was more violent than the other convicts। so এইটোক লৈ আমি একো কৰিব নোৱাৰো because it was followed as it is given in the law book। so পিছত যদি এইটো চেঞ্জ হয় এইটো আমি ক'ব নোৱাৰো। for now like should be treated alike and unlike should not be treated alike। now exceptions to equality। so এই আৰ্টিকলটোৰ exception বিলাক হ'ল the president of India and the governor of states enjoy certain immunities under article 361। so president আৰু governor বিলাকে তেওঁলোকৰ ইচ্ছামতে কাম কৰিব পাৰে and they are not answerable for their deeds। then in respect of publication in a newspaper or in a radio or television, যদি জাৰ্নেলিষ্ট এজনে পাৰ্লিয়ামেণ্ট বা ষ্টেট লেজিসলেচাৰৰ ভিতৰত হোৱা কাম কাজৰ ৰিয়েলিষ্টিক ৰিপৰ্ট এটা পাব্লিছ কৰে নিউজ পেপাৰ বা টেলিভিছন বা ৰেডিঅ'ত, চ' তেওঁৰ এগেইনষ্টত একো প্ৰচিডিং হ'ব নোৱাৰে বা কেছ হ'ব নোৱাৰে। দেন MP আৰু MLA বিলাকে ষ্টেট লেজিসলেচাৰ বা নিজৰ বা পাৰ্লিয়ামেণ্টত যিখিনি কথা কয় তাৰ বাবে তেওঁলোকৰ এগেইনষ্টত একো প্ৰচিডিং বা কেছ হ'ব নোৱাৰে, দে আৰ ফ্ৰী। দেন Article 31C is an exception to Article 14। এইটো কি হয় আমি পিছত ডিসকাস কৰিম with Article 31A and 31B। Then the foreign sovereigns or rulers, ambassadors and diplomats enjoy immunity from criminal and civil proceedings। Then at last the UNO and its agencies enjoy the diplomatic immunity। So all these are covered under exceptions to equality। Now prohibition of discrimination on certain grounds। so article 15ত কোৱা হৈছে যে the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex or place of birth। second provisionটোত কোৱা হৈছে যে no citizen shall be subjected to any disability, liability, restriction or condition on grounds only of religion, race, caste, sex or place of birth। ইয়াত দুটা provision আছে কিয়ক লৈ। first হ'ল access to shops, public restaurants, hotels and places of public entertainment। then the use of wells, tanks, bathing ghats, roads and places of public resort। কিন্তু এই আৰ্টিকেলটোৰো কিছুমান এক্সেপশ্যন আছে। ফৰ এক্সাম্পল the state is permitted to make any special provision for women and children। for example womenৰ কাৰণে সিট ৰিজাৰ্ভ কৰা হৈছে আমাৰ এছেম্বলি বিলাকত বা ইলেকশ্যনৰ ক্ষেত্ৰত আৰু ফ্ৰী এডুকেশ্যন প্ৰভাইড কৰা হৈছে চিলড্ৰেনৰ কাৰণে। then the state is permitted to make any special provision for the advancement of any socially and educationally backward classes। for example ST SC বা OBC ৰ কাৰণে গভৰ্ণমেণ্টে যিকোনো প্ৰভিজন কৰিব পাৰে। then regarding the admission to educational institutions। so socially আৰু educational backward classৰ কাৰণে গভৰ্ণমেণ্টে private বা government educational instituteত সিট ৰিজাৰ্ভ কৰিব পাৰে। so this provision was added by 93rd Amendment Act of 2005। then equality of opportunity in public employment। so under Article 16 it provides for equality of opportunity for all the citizens in matters of employment or appointment to any office under the state। ইয়াৰ exception কিছুমান আছে, সেইটো হ'ল the parliament can prescribe residence as a condition for certain employment or appointment। so আমাৰ কিছুমান জায়গাত কিছুমান চাকৰিৰ কাৰণে permanent residential certificate দৰকাৰ হয়। then the state can provide for reservation of appointment or post for certain classes। then an office related to religious or denominational institution or a member of its governing body। for example এটা religious bodyৰ authority সেই particular religionটোৰ এজন মানুহক দিব পাৰে। then abolition of untouchability। so article 17 abolishes untouchability and forbids its practice in any form। কিন্তু untouchability আমাৰ কনষ্টিটিউচনত ডিফাইন কৰা নাই, কিন্তু according to Mysore High Court it refers to social disabilities imposed on certain classes of persons by reasons of their birth in certain caste. So আমি lower caste বুলি কাকো discriminate কৰিব নোৱাৰো. Otherwise, we will be convicted under the Protection of Civil Rights Act of 1955 and it is punishable on the ground of untouchability. Next, abolition of titles. So, under Article 18, abolishes titles and makes 4 provisions in that regard. It prohibits the state from conferring any title except a military or academic distinction on anybody, whether it is a citizen or a foreigner. Then, it prohibits a citizen of India from accepting any title from any foreign state. Then, a foreigner holding any office of profit or trust under a state cannot accept any title from any foreign state without the consent of the president. Then at last, no citizen or foreigner holding any office of profit or trust under a state is to accept any present emolument or office from or under any foreign state without the consent of the president. So, Britishৰ টাইমত যিবিলাক টাইটেল আছিল মহাৰাজা দিৱান Rai Bahadur, Raj Bahadur, এইবিলাক টাইটেল নোহোৱা হৈ গৈছিল after the commencement of the constitution. Now, what about the national awards? For example, Bharat Ratna, Padma Vibhushan, Padma Shri. So, constitution কোৱা হৈছে যে national awards বিলাক article 18 আন্ডাৰত নাহে because they are not hereditary titles. They are given on the basis of merit. কিন্তু national awards বিলাক মানুহে নিজৰ নামৰ লগত প্ৰেফিক্স বা সাফিক্স হিচাপে ইউজ কৰিব নোৱাৰিব. সো আমি যদি ভিডিওটোৰ সামাৰি চাব খুজো আমি কি ডিসকাস কৰিলো হেতু হল ফাৰ্স্ট আমি ডিসকাস কৰিলো ডেফিনিশন অফ ষ্টেট আন্ডাৰ আৰ্টিকল 12 দেন আমি আৰ্টিকল 13 ডিসকাস কৰিলো যে যিবিলাক লয় ফান্ডামেন্টাল ৰাইটস ভায়োলেট কৰে দে ক্যান বি ডিক্লেয়াৰ্ড unconstitutional by the Supreme Court of India. Then article 14 আন্ডাৰত আমি ডিসকাস কৰিলো equality before law. Then we discuss prohibition of discrimination on certain grounds under Article 15. Then we equality of opportunity discuss under Article 16. Then we discuss abolition of untouchability under Article 17. Then at last we discuss abolition of titles under Article 18. So at this we come to the end of this video. Hope you like the video. If you like the video, please share it and subscribe to our channel so that you can get timely update of our videos. So next video to the Thank you.